A divorce is an absolute dissolution of marriage. But can this absolute dissolution exempt a man from all his liabilities towards his wife? Recently, Imran Hashmi's new movie has hit the big screen. Not the one that you're thinking about. We are talking about the recent movie with Yami Gautam, which basically revolves around the landmark case of Ahmed Khan versus Shah Bano Begum. Ahmed Khan married Shah Bano Begum in the year 1932. From this marriage, they had 5 children. You might think this was a happy marriage, but not so the case. In 1975, Ahmed Khan drove Shah Bano Begum out of his house because while he was having a midlife crisis and time to buy a sports car, he decided to marry a younger girl. But Shah Bano Begum decided to challenge the law and proceeded against her husband in the court, seeking 500 rupees as maintenance. But you know what? Her husband was a lawyer and he knew the law too well. And therefore, he decided to divorce his wife and exempt the obligation that is posed upon him by section 125 of CrPC, which makes a man maintain his wife, a wife including a divorced wife. In the year 1978, Ahmed decided to divorce his wife.
Talaq. Talaq. Talaq.
Which is an irrevocable mode of divorce. But Ahmed thought he is a kind-hearted man and stated to the court that I have already paid 200 rupees every month to my wife as maintenance while she was in a marriage with me, and I provide 3000 rupees to the court as the amount of dower, so when the Iddat period is over, you can give the money back to this woman and I have no obligations against her. Ahmed Khan placed heavy reliance upon religious texts, that is the Shariat, and stated that post the Iddat period, which is the waiting time of around 90 days, the man shall have no rights or liabilities towards his wife. And therefore, as the Iddat period is over and the dower sum is paid to the wife, he shall no longer maintain his wife under section 125 of CrPC. Though aged 60 at that time, Shah Bano was not weak and she approached the courts of law, seeking maintenance. The magistrate court awarded a sum of rupees 25 per month as a princely sum to be paid by the husband to the wife. At that time, Shah Bano stated, my husband earns around 60,000 rupees per month, and what do I get? A penny out of that. She decided to proceed to the High Court. The High Court ordered a sum of 179 rupees as maintenance. Aggrieved by this, Ahmed Khan approached the Supreme Court via a special leave petition. The Supreme Court had to decide some really interesting questions. Number 1. Can a man escape his liability under 125 if he divorces his wife? Secondly, does a Muslim man have no liability towards his divorced wife under section 125? Thirdly, is there any kind of a provision present under the Muslim personal law that allows a man to pay a sum towards maintenance for his wife? Now these issues revolved mainly around 2 provisions, section 125 and section 127 of CrPC, which we are pinning down here. Ahmed Khan also took the help of intermediaries such as All India Muslim Personal Law Board to argue that traditional knowledge and traditional scriptures are supposed to be inclined upon to decide personal laws. At the same time, it was also argued by Khan that within the provision of 127 of CrPC, it is very clearly mentioned that maintenance cannot be sought if a total sum as a consideration has already been paid under any customary or personal laws. Now it was time to decide whether meher constituted that sum. The court gave a very progressive judgment by holding that number one, CrPC is not a civil law, but it is a secular law that is applicable no matter what the religion is. 125 does not depend upon the religious identity of the women, but it includes to everyone who is in necessity of that maintenance. Second, that there is a scope of maintenance even after the Iddat period. The Iddat period does not take away the liability of the man even after the Iddat period if the woman is in requirement or necessity of maintenance. The man has to maintain the Muslim woman. Third, the court here defined what meher is and stated that meher is not a sum that is paid on divorce, but it is a sum that is paid on consideration of the marriage. Though meher can be paid either on divorce or when asked, but divorce is just a potential time when the meher is supposed to be paid. Otherwise, it is not a money that is paid on divorce. It's just a consideration, as Muslim marriage is considered to be a contract. By affirming that meher is not an amount that is paid in consideration of a divorce, the court clearly put meher outside the scope of 127. The fourth and the most important part of the judgment was towards Article 44 of the Constitution and the state's failure to implement the same, determining the status of women in the society. However, a political move deteriorated the stand of the Supreme Court. The evolving Rajiv Gandhi administration faced severe backlash by religious fundamentalists. And at that time, a legislation was introduced to overturn the apex court's ruling. Muslim Women Protection of Rights on Divorce Act 1986 was passed by the legislation to put divorced Muslim women outside the purview of Section 125 of CrPC, and we proceeded back to its original position. However, with time and patience, law always provides justice, and this entire thing was overturned one time again in Daniel Latifi's case in the year 2001. And though the story seems to end in 1986, the same is not true. The gender battle went on for a really long time until 2001, when the Supreme Court, in the case of Daniel Latifi, decided and upheld the provisions of Muslim Women Protection of Rights on Divorce Act 1986, but only with the implementation of the provisions of equality as per under Article 14, and also stated that a provision cannot be unfair and equality has to rise and shine in all cases. It takes time, faith, and patience, but law never does injustice. I hope you liked our video, and if you want more of such amazing and interesting stories, stay tuned, subscribe, and please comment.